The South African economy is of the second largest on the African continent of 52 countries. And the retail sector is the second largest employer in South Africa, just after the government. In this week's show, we take a look at the retail sector and ask whether those workers are sufficiently protected, whether COIDA is in fact being applied, and what to the benefit that piece of legislation can come to the retail workers in the South African market. Workers' World starts now.
From England to Poland, every step across the ocean, the ruling classes, them is in a mess. Oh yes, the capitalist system a regress, but the Soviet system now progress. So which one of them you think?
Welcome to our Workers' World show. I'm your host, Shirik Trubodi. Thank you once again for joining us. We continue our series focusing on COIDA, a piece of legislation that's meant to protect workers, particularly, of course, in the working field. And this time around, we're focusing, of course, on the South African retail market that is a giant in comparison to other countries in Africa. It is highly profitable and it is dominated by major companies such as Shoprite-Checkers, Pick n Pay, Spar and Woolworths. The retail sector is the second largest employer in South Africa, just after the South African government. The domination of these major retail companies and their high profit margins come on the back of the workers' low wages as well as the poor working conditions. The average lowest paid worker in the wholesale and the retail sector would need to work 21 months, so in fact to earn what an average CEO would earn in just one day. In today's show, we take a look at the retail sector in South Africa and the conditions of the workers, their safety, and how legislation like COIDA can certainly benefit them. All right, and we're having this conversation with Crosby Boy, the Regional Secretary for SACAO here in the Western Cape, and Wonderboy Shisabe is the General Secretary at Thorn, the Transport, Retail and General Workers Union. Thank you very much, gentlemen, to the both of you for having joined us. I want to start off with you, Mr. Boy. Maybe give us an overview of the retail sector at the moment. In regards to the employment of workers, how would you describe the overall level of compliance with legislation and working conditions?
Okay, firstly, let me start with the major retailers in our sector. One is Shoprite-Checkers, Pick n Pay, Massmart Group, which consists of Macro, Game, Builders Warehouse. We, in our sector also, we have X Group, which was also is a major retailer in our sector. In terms of the working conditions, in all these companies which I've mentioned, we entered into relationship agreement, which gave us a right to negotiate wages and conditions of employment, each and every or multi-year agreements in that regard. So we have made a lot of achievements in some companies. Like in the case of Pick n Pay, we have, I think SACAO is the first union to enter to sign an agreement which covers the rights of the parents or parental rights, which give those workers rights to go to maternity leave, including fathers' maternity leave, before even the act came into being enacted. The challenge we're facing again in this case is the atypical forms of employment, and where you'll find that majority of workers are the so-called part-time workers, flexi-time workers, or variable time employees in the case of Pick n Pay. But also the union is trying to make strides in ensuring that those workers' conditions are improved. Because in most cases, you'll find some retailers, they don't actually pay or cover social benefits like provident fund or medical aid, but in Shoprite-Checkers, I can mention that we made inroads in terms of that we improve the condition of those workers, which are called part-timers. Also, they are benefiting from what we have negotiated over the past years.
Okay, and one of the changes or the challenges, and I'll bring Wonderboy in here, would have been the change in operating hours for some of these retail establishments, sometimes they open a lot earlier and close a lot later. Have those been accommodated in terms of the stipulations of the Basic Conditions of Employment Act?
Besides Basic Conditions of Employment Act, we also called upon the employers to provide safety transport for those workers who work late shift, which they are doing. We have challenges in clicks, but we are currently addressing that the employer must provide transport for late trading employees. So it is we are addressing that in terms of the Act again, we ensure that the employers comply with the provisions of the Act, including the agreements entered into.
Yeah, I want to ask Wonderboy whether that is maybe just some opening remarks from yourself and what your impressions would be of the level of compliance that your members are in fact observing on the ground.
I think there is a bit of a confusion in terms of the names that we are utilizing. They are closely related. So the presenter is actually directing the question to myself. I think perhaps if I could relate, as Mr. Shibas said, it would assist under this circumstances because it would allow us some space not to create a confusion when we actually interact with a question that has been posed.
Okay, what are then some of the issues that your members have detected, Wonderboy, in terms of the not just level of compliance, but the general working conditions environment within the retail sector?
All right. Let me make an example of one case here, which was brought to our attention. One member, for example, was scheduled late shift without actually following proper procedure in terms of consultation with that member. But then that member complied. The unfortunate incident happened in that member was subjected to being a victim of gender violence because there was no transport, and she ended up being a rape victim in that particular matter, which we have addressed with the employer concerned. In terms of the conditions, of course, the hours they are working, they are very, very unsocial, of course.
Okay, Wonderboy, if I can bring you in here again, the observations around the working hours, have that largely settled, or is that quite clearly defined in terms of the working contracts that are in place at the moment? All right, it seems that there may be some challenges with the connection to Wonderboy Shibase, the Transport, Retail and General Workers Union. Crosby, I want to look at the issue around contracts, the employment contracts, and whether most of these workers are in formal employment with permanent positions, or whether there's a high amount still of casual workers that are still being used by labor brokers, for instance, in the sector. Has this been your observation, Crosby?
Okay. I think earlier on I pointed out to you that in all these major retailers, there are casual workers, or what they call part-time workers. Majority of them are part-timers as compared to full-time or permanent position within the company. We have actually started to address that particular matter, in particular with the one major retailer, Shoprite-Checkers, where we said they must actually convert those part-time workers into full-time positions. There's an agreement which was agreed upon that after 7 years, all those workers will be converted into full-time positions.
Yeah. All right, and I want to come back to that conversion and what the impact has been certainly on some of those workers. Once we do return from the break, it is Workers' World. Do stay with us. We are talking about the retail workers that have often been subjected to casualization and labor broken practices, but now the conversation, of course, has shifted to Basic Conditions of Employment Act and COIDA and how this applies to some of these workers. We've heard about gender-based violence as a particular challenge, certainly within the sector as well. We're talking to Crosby Boy from Sakao, as well as Wonderboy Shibase from the Transport, Retail and General Workers Union. Mr. Shibase, I want to understand from the position of COIDA whether this is often applied and whether workers are using this mechanism to protect themselves within the retail sector.
All right. Thanks. Based on your question, firstly, I would like to address the concern for those viewers or listeners who are not familiar with the term COIDA. Basically, COIDA is Compensation for Occupational Injuries and Disease Act, which covers most employees, including casuals and part-time workers, who have sustained injuries or illness during the course of their employment. So basically, the COIDA Act, it is regarded as no-fault compensation that is usually granted to employees in the event they sustain injuries during the course of their employment, or alternatively, they catch diseases while in the scope of their employment, or rather rendering their services to the employer. It is also common cause that based on the actual sector that these employees are working, most of them are not fully previewed in terms of what the portion of the Labor Relations Act, or rather the legislation that regulates the actual COIDA does cover them for such benefits in the event they either sustain injuries, or rather they catch diseases in the course of their employment. So basically, that means that the labor parties across the globe have a very huge responsibility in terms of liberating and educating the constituents of whom we represent, so that they will be much more familiar in terms of the processes that they have to undergo.
Okay, and I wanted to speak up on that because whether, Mr. Boy, whether workers in the sector are in fact receiving compensation. And even before we get to compensation, part of the other challenges on previous occasion was the registering of the workers for COIDA and then to apply for the employer to apply on their behalf. What is the observation or the assessment about the way in which COIDA is administered to these workers in the retail sector?
Thank you for the question. In our sector, we have not yet received any major challenges insofar as the compliance with COIDA. Where there are cases, obviously, the employers do comply in terms of ensuring that all necessary documentation are filled in, workers have access to compensation, and we, in a nutshell, we have not yet received or experienced such huge problem in our sector.
Okay, and would they then, just to understand, if there aren't any major problems, is that from an administrative perspective, or are workers just not finding themselves in high proportion being injured at work?
In this case, I'm referring to injuries reported.
Greetings once again.
Which were brought to our attention.
Okay, all right, Mr. Shibase, is that your observation as well? There aren't very many injuries that would require, for instance, an application to COIDA or benefit to use COIDA in this instance? All right, it doesn't seem that we're going to be able to get that connection going. I found that a bit, I suppose, welcoming, the fact that, no news, I suppose, is good news. But given the types of environments that one finds within the
Apologies, I've
retail,
lost you
particularly in
between
merchandising and so on,
or-
is there a general sense of safety then and compliance with safety standards within the retail sector? I'm
Summarize
asking,
again.
given the extent of the retail sector, to which, of course, a lot of it requires merchandising and the moving, particularly of that merchandise, whether then, if you're saying that there hasn't been much of an issue, does that point to there not being a lot of applications for COIDA for injuries? Or does that mean that there aren't that very many injuries that are being recorded in the workplace for retail workers?
Just to answer your question again, I said earlier on, there have been no major cases reported for our attention to attend to in our sector. As and when those cases are reported, then obviously we make sure that the employers do comply with the provisions of the Act. Of
And
course, the Act was
how would you
improved.
know about the cases? Whose duty is it to report it?
It's our members and employers, of course.
Is the fact that there isn't sufficient enough cases to point to, as you say, that you haven't had much issues in terms of COIDA and applications to COIDA, is that because the cases aren't being reported? Or is it because, it's just, not being brought to your attention? I'm trying to understand because I found it a little bit astounding that there aren't much cases to speak to within the retail sector.
Well, I'm not
All right.
privy to that information, but I repeat again that there are no major cases reported to us for our attention to address same.
Okay, let's go to a break. Once we do return, we continue our conversation, of course, about the retail workers and the impact to the working conditions, of course, that they are subjected to. That and more after the break. Do stay with us. We are talking about the retail sector, that is the second largest employer in South Africa, just after the government, and looking at certainly the exponential growth of the sector and the amount of employees that is within its umbrella, whether it, of course, is observant to the conditions of work that is adequate and fair. And a part of it, of course, as we've been reflecting, is the Basic Conditions of Employment Act, the Labour Relations Act, and of course COIDA, that's meant to respond to any particular occupational injuries or diseases that may be either contracted or found to have happened on the work site. Mr. Shibase, the observation being made there by Sakao is that there aren't very many reporting cases of injuries or diseases being contracted at the workplace. Is that your union's observation?
All right, thanks. Firstly, I would like to reflect or rather outline or provide a brief background in terms of the common health issues or other injuries that employees, specifically in the retail sector, are most likely to sustain. So firstly, it's the slips, the trips and the falls, a catching of fire, violence, lifting, manual handling, and risk of workplace bullying. So under these circumstances, you would note that, for instance, some employees would fall within their and they would sustain maybe muscle strains or sprains, cuts, or scrapes. So they would not necessarily take those injuries seriously because it would seem like something minor, but as time goes by, it actually develops and becomes a much of a big issue. So we all understand that in terms of the COIDA Act, it is very specific that if an employee has sustained an injury during the course and scope of their employment, there is a certain period of time that is allocated for such incident to be reported in order for that particular employee to lodge a claim. So basically, the inability for employees to take whatever minor injury that they have sustained, not to use their own personal observation, but rather to rely on a document that has been concluded by a medical practitioner who is in a better position to examine an employee. Perhaps that's the major issue that actually limits or rather reduces the number of claims that one would see coming from the actual retail sector.
I'm asking whether that process that you have highlighted, whether it is that process that is leading to an underreporting of injuries and diseases in the workplace.
Yes, indeed, that is correct. The inability to report incidents on time actually limits the chances of employees for being fairly compensated for injuries that they have sustained from their workplaces.
Okay, Mr. Boy, that's a very different scenario, and that's what I was trying to understand a bit earlier, that the underreporting of injuries and diseases is not to say that they're not happening, it's to say that there's too much paperwork and processes involved before they get reported.
Okay, thank you. We have taken a view as an organization that there's a need to embark on vigorous education and training for our members around this pieces of legislation, so that when the incident occurs, we are able to dictate and also detect that info and ensure that we follow the rules or law. So our education department is currently embarking on that process as part of training to our members, because some members, they may not be aware of the provisions. That is why we said we must prioritize the question of education around the Act.
Okay, but I find it a little bit astounding that you first say that there isn't much reporting, there aren't many cases, to now saying your members aren't quite aware. How in touch is the union then with its members?
Yes, I said earlier on that there has been no major reports around that. If there are any issues raised, definitely we will then come in and make intervention in terms of assisting those workers. But also we're saying...
What is your understanding of major? Are you telling me that since COIDA was applied, no heister driver got injured, no person working a pallet got injured, no person that's loading things got injured or contracted some sort of exposure to a disease? Are you saying to me that across the sector, across all your members, that injuries is not a common and a regular experience in the workplace?
No, not at all. I'm not saying that there's been no injuries at all, because some workers are subjected to unbearable working conditions. So, but I'm saying there's a limited reports which were brought to our attention.
But then that raises the question about how in touch you are with your members.
Come again?
It raises the question about how in touch you are with your members, because you just told us a short while ago that there aren't that many cases and that it's not even really a cause for concern. When I'm pointing out to you now that it seems to me unfathomable that there aren't any cases, you're saying it's because of a lack of education. So if there isn't a reporting, the education isn't there, what then is the purpose of the union?
That is why I'm saying that part of our responsibility as a union is to ensure that we empower our members in terms of knowledge around these pieces of legislation.
And when is that happening? What is the program? Is there a program to which training is happening, to which your members are being duly informed about the provisions that's available to them? Because it was a big fight to get the legislation. The legislation is now there. What are you doing then to inform your members?
No. I'm saying we have attended to these matters. For example, the Department of Employment and Education, there were actually workshops around the country, even here in Western Cape, where we engaged with the department around same issues they are raising. So what I'm saying, it should not be end there in that level, but we should take it back on the ground so that members do understand the implications and the interpretation of the law.
I found your reasoning astounding. I'm sorry, Mr. Boy, because are you saying there's no shop steward, no representation of the union that's on the floor that is noticing these injuries taking place and then enacting the legislation as it should be?
We do have shop stewards. That training is aimed at empowering shop stewards in the shop floor. Because in every sector where we are organized, we normally ensure that shop stewards are elected, and there are structures where they meet from time to time on monthly basis in our structural meetings.
Right.
So that if there are issues raised, we are able to respond to such matters.
Well, to me it sounds like workers need to be asking some of their contributions back, because what then is the purpose of the unions in this particular regard? And we can continue this conversation, of course, at another time. It brings to a conclusion our conversation about COIDA and retail workers. You have a lovely day until we talk again. Thank you very much for tuning in. This has been Workers World. My name is Shirik Trubadi. Have a lovely day. Bye-bye.